Wow.
And your reaction to the expert with the Commonwealth saying that it wasn't 2:27 or 2:26, that it was actually after 6 a.m.
Celebrate says 2:27, and it was deleted. Celebrate that.
What do you
He
think
would
about
have
that
been
battery? That battery.
went.
All right, here we go with the shenanigans from Judge Bev.
Reminiscent of what we saw in the first trial. A lot of sidebars, a lot of arguments. Your thoughts on the kickoff of round 2 for Karen Reed?
Well, I'm already getting pissed off. I'm pissed off that we're here to begin with because of the double jeopardy that I believe was established. And if it was any one of us that were in the same situation, or the prosecutor's family members or the judge's family member in the same situation in a different court, they'd be screaming to the high heavens that this is unfair and unjust. All right.
Mm-hmm.
It is a miscarriage of justice to proceed with the 2 charges that a previous jury had already acquitted Karen Reed on. OK, I don't know how this judge or this prosecutor can sleep with themselves at night, lay their heads down on a pillow. I don't understand it. It just tears me apart. I've dedicated my life to fighting injustices, and this is huge, a huge injustice. That said, I don't care for this prosecutor. I think he's highly unethical. Okay, he's made horrendous statements in motions, and nothing happens to him. No punishments. Okay.
Did you turn records over to the Superior Court?
I provided a copy of that production notice to Ms. Little.
Did you provide the records to the Superior Court?
I didn't directly email that to the court, no.
Did you indirectly email it to the court?
It was my understanding that it would be passed along to the court.
So you did not, pursuant to the order, provide the records to the Superior Court, did you?
Not directly to the court, no.
Back in March of 2024, you spoke on the phone to Mr. Jackson?
Yes, sir.
A number of times?
Yes, sir.
And as you spoke, you began to become familiar with him and his role in this case, didn't you?
We corresponded about, again, our expected testimony here at trial, yes.
I'll ask it again. Did you become familiar with him and his role in this case when you spoke to him?
I understood him to be the defense attorney on the case, yes.
Did you speak to anybody other than Mr. Jackson about this case before the first trial?
I don't believe so, no.
Did you speak to anybody since then on the defense team? Who?
I believe Ms. Little and Mr. Alessi.
Okay, and how about Ms. Reed?
No, sir.
Did you ever have any Zoom meetings before the first trial?
No, sir.
Did you ever have any group conferences before the first trial?
I don't believe so, no.
Were you ever on the phone before the first trial in a conversation where you and Dr. Rentschler both were on the call?
There may have been an instance of that. I just don't recall.
Well, think back.
I don't recall.
At some point, you were contacted by Mr. Jackson and you...
So I believe that would have been the very first phone call that I had with Mr. Jackson.
Right. Was that more than about logistics?
Well, I think we were trying to figure out what should we do. I will note that this was a very abnormal situation for me, being involved in a federal investigation and then ultimately being called as a witness.
No.
Well, I'm trying to answer your question.
But you're not. Did you talk about more than logistics?
So, are you finished with your answer, Dr. Wolf, or are you still answering?
I was still trying to answer.
Go ahead, finish.
Not work with. We could be called on the defense's behalf to testify. And for that matter, the Commonwealth could have also contacted us and utilized us at trial as well, if they should, please.
So when did you become an advocate for the defense?
Interesting.
Do you feel like you're an advocate for the defense?
No, sir.
Are you sure about that?
Sir, I'm on the science and the analysis that I've done. That's the side that I'm on.
You sure are.
I don't like Judge Bev either, and her condescension to the defense team and the way she treats the prosecutor with kid gloves and slams the defense team. I'm sorry, I feel she's biased.
Yeah,
this
you're
is
definitely not
crazy.
alone. You hit the nail on the head. I mean, Judge Beverly Cannone, very, very one-sided, and it's not even, she's not even trying to hide it. She's blatant about it. The way this evidence was collected with the red Solo cups, the leaf blower,
Please, and
you know,
and the Canton PD's audit and giving themselves attaboys and saying, you know, they thought out of the box. No, they're forensic standards. You follow the forensic standards. You didn't call a crime scene team out there. You had some search team that was not forensically qualified to be doing any of this. Where's the crime scene investigators? Where were they? Because they would have stopped that immediately. The investigation was flawed from the beginning. Okay, all right, and there's all kinds of ethical and possible criminal activity afoot here. Yeah, and not on the part of Karen Reed.
No, it's all on the part of the Commonwealth and how the judge is running her courtroom.
The big moment of the day clearly is this change of testimony where you had Kerry Roberts, who told the grand jury that she heard Karen Reed ask Jennifer McCabe to Google hypothermia, and today she said this.
Understood the question. I didn't know it was that you heard, so I was explaining what happened in the back of the car. I obviously got the question wrong because I did not hear anybody ask about a Google search.
You know, when the government promises you something in their opening statement and their witnesses don't support it, and at best for the prosecution, there was a misstatement. What's best for the defense is that she lied. And here's the bigger point. It's not just about her testimony. Mm-hmm. She testified in front of the grand jury. Mm-hmm. Was she lying then? Is she lying now? And the argument that I would make as a defense lawyer is, had the prosecution done a fair evaluation of this case in front of the grand jury, presenting the evidence honorably and credibly, we wouldn't be here.
It's an ugly look, you know, just the way everybody's acting and the secrecy. You talk about cell phones being upgraded after requests from the defense to get copies of the phones, and you know, I just was time for an upgrade. There's so much BS in this trial.
Destroyed. Okay,
yeah.
You know, the one ruling pre-trial about not allowing the defense to bring in a crime scene expert to explain to the jury how none of the standards were followed. It blew my mind. It blew my mind.
Here we are with more delays upon delays upon delays.
And now she's limiting what they can say on opening arguments. This is just, you know, bullshit. And then you wonder why the feds jumped in and started looking at these people. Okay, they need to look at this judge too. I'm sorry. All right, her behavior. I mean, I've testified in a lot of trials. All right, and been a part of a lot of cases, high-profile cases. Never seen a judge act like this. Talk about miscarriage of justice. Unbelievable.
So then we come to yesterday on direct examination. Do you recall that Mr. Brennan yesterday asked you, before you left, were you having any conversations with the defendant? And you answered yes. Recall that yesterday?
Is that at the hospital?
I'm asking you yesterday, do you recall Mr. Brennan asking you, before you left essentially the scene, were you having any conversations with the defendant? And your answer was yes.
You're talking about Lee, I'm just trying to make sure we're talking about the same instance. Are we talking about when we left the hospital or when we left Fairview Road?
When you were at Fairview Road, leaving Fairview Road. We're talking about the same subject of what Ms. Reed supposedly told you or asked you.
So on the way to, you're talking on the way to the hospital in terms of left, when we left.
Well, before you left. He meant before you left the scene.
Okay, no, I'm just trying to clarify.
Again, it's the same conversation, Mr. Whitley. I'm not trying to trick you.
Mr. Yannetti, he just asked for a point of reference. It's clear. Now go.
Understood. And Mr. Brennan said, can you share with the jury what those conversations were about? And your answer was, so we were talking, she was upset. She kept asking if there was any chance her husband could be alive, even sitting outside in the snow without any coat for many hours. Do you recall that answer that you gave yesterday on direct examination?
Yes.
That was the first time that you mentioned that she said, supposedly, or asked supposedly, about him sitting outside in the snow, correct?
I was just using phrases generally speaking. I wasn't, at that point I was paraphrasing. I was not speaking verbatim to what she said.
Let's try that again. That was the first time that you mentioned that she claimed or asked that he was sitting outside, correct?
It could have been sitting, laying, being.
Let's try it a third time.
So just ask the question, not let's try it.
Sure.
Look, let's talk a little bit about Trooper Michael Proctor, former trooper who was fired for calling Karen Reed vile names and text messaging between colleagues and sergeants, seeing him talk about her in a derogatory manner. An embarrassment to the Massachusetts State Police. He got fired, but what did it take? 6 months? A long period of time. before they fired his ass. Ed,
Listen,
thoughts?
in any other case, with no chain of custody for the evidence, there wouldn't be a case, all right? If you could not establish the chain of custody for the evidence that they're going to use in the prosecution, no prosecutors in the New York 5 District Attorney's Office that I know of would proceed further with the case, having no chain of custody, and no judge that I know of in the New York City 5 boroughs would allow the case to go forward with no chain of custody for the evidence. When things are found and who found them, and no crime scene, no photographs, no, it's just ridiculous. And then the manipulation of the Sally Port video, nobody's held accountable for this. Okay, this is ridiculous. Ridiculous. It's a criminal justice farce.
There's a lot of people obsessed with this, and I don't know if it's an obsession because of the foul-ups from the police and the circus atmosphere that surrounds it, or just some people are obsessed because they want to see justice. They want to see justice for who? Who gets forgotten about this whole thing? John O'Keefe, the person who can't speak. Ed?
That's right. Look, I've been a part of numerous investigations in very similar circumstances, okay? There was a case in New York City in an emergency response community, I won't say which one, where there was friction between members of a particular emergency response team that worked together, and a fight occurred between two members of the emergency response community, okay? One of these people were so badly beaten.
With a chair.
No, I'm not going to give the details. It was so badly beaten. The individual had to be rushed by the other emergency responders that were present and didn't stop the fight to the hospital in uniform, and then gave the emergency room a story that this person fell down the stairs. And the hospital and the doctors knew that this person had not fallen down the stairs based upon the injuries sustained by this individual, okay? And they immediately called law enforcement to investigate, okay? When all was said and done, members of that emergency responder team were arrested and or convicted and lost their jobs because they got into a heated fight over something silly. Instead of dealing with it, supervisors present and so forth, instead of dealing with it appropriately and handling it as adults, they dropped down to this juvenile behavior and almost killed somebody and then tried to cover it up. I've seen it several times, especially off-duty incidents.
Drinking. Involving
drinking.
And as we know, everybody drinks in this town.
Right. And then you take the whole story. Is it beyond the realm of belief that, you know, all of these off-duty cops drinking in a bar and the off-duty ATF agent drinking in a bar? Video footage is crucial. It's key to this investigation as to what happened. And the text messages between Karen and the ATF agent, crucial. Going back to that house after the bar was a huge mistake on Karen Reed and John O'Keefe's part. Should not have done it, okay? Hindsight being 2020, should not have done it. Because when Karen left John alone, that opened the door for this confrontation.